Freddie Wilkerson, you want to explain to me what this is?
Your Honor, Mr. Netherton has filed a pro se motion and, I'm not really involved in that necessarily, but I wanted to be sure to get it on your docket so that he could make his argument to the court about why he believes that his VOP judgment should be set aside, I suppose.
Well, number one, this is a judgment he's seeking to modify that was entered by Judge Lockhart Mash in May of 2024. So in my opinion, if he's seeking to modify that judgment, she would be the appropriate person to enter it. His motion says, I had come to court on May 28th and received a sentence of 3 years probation upon release to a rehab, Jack Jean Shelter, and upon completion of 6 months. I have a hold out of Sumner County. I may be reading an older, but I guess I'm reading that older. All right. Motion to appeal my sentence that's in effect. I need help by the rehab or other drug court. I hear the law is changing for drug court and I'm willing to wait or do whatever I have to be able to better myself and get back out there for my kids. I know I've made a mistake and have consequences, but have never received help as in rehab or anything like that. I need help. The law is rehabilitation before incarceration. It's interesting. Thank you for your time. Well, apparently what he's wanting to modify is the violation of probation revocation order that was entered in October of 2025. And in that order, it was Judge Turnbow that entered the order, and it's basically he conceded the violation was revoked to serve his 3-year sentence. Is that what I'm understanding? And it is now, he's filed in March of this year a motion to appeal your sentence. Problem is that the period of time for you to appeal a judgment of this court is 30 days from the entry of the judgment. That judgment order was entered on October the 28th of 2025. So November the 28th of 2025 would have been the last day for you to file a notice of appeal of that. So you are now in a situation where that your request to appeal that has expired. In the body of what you're saying is apparently that you are asking to be allowed to go into rehab rather than simply being incarcerated. And to do that, you'll have to go before the judge who revoked you and serve your sentence. So Judge Turnbow will be here when? We'll move you to June and let Judge Turnbow consider whether or not to give you rehab rather than serve the balance of your sentence. June what? June 30th.
All right, thank you, Your Honor.
All right. Who we got?
Page number 2, docket number 19710, 19713, John Frank.
Judge, Mr. France is not client. That's going to be completed today. Judge, there's 2 case numbers. One is dealing with General Sylvie. The other is dealing with General Willoughby. Case number 19710, that is with General Sylvie. That is going to be amended to simple assault, an A misdemeanor. That'll be 11 months to 29 days, suspended to supervised probation, credit for time served, and no contact victim. The rest of the counts will be dismissed in that case. And then as well as 19713, that's going to be amended to theft under 1,000, another A misdemeanor. That will be 1129, suspended to supervised probation as well. That will be concurrent to 19710. I believe that's the only count in there, but anything else would be dismissed in any other cases. He's got jail credit from 9/8 to 9/10, 10/23 to 10/25, and 12/3 to 12/19 of 2024. Then 1/8 to 1/15 of 2025, and 3/10 to 3/30 today's date of 2026.
All right, Mr. Krantz, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
Jonathan Krantz.
Mr. Krantz, you're here today on a couple of different indictments. You've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of those charges and talked them over with your lawyer? And you and Mr. Vaughn discuss the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest or nolo contendere. Do you understand that means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when General Sylvie tells me what their evidence will be if this case went to trial. And I will use her evidence that she presents to me to find you guilty according to this agreement. Do you understand that?
Yes, sir.
Do you understand, however, that you have a right to plead not guilty and have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you would have the right to have a lawyer and have one appointed, as I've done with a public defender.
Yes, sir.
Do you understand that if at trial you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
Do you understand that that's going to result in 2 misdemeanor convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
I do.
Do you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
It is.
Anybody forcing you to do this against your
No,
will?
sir.
Do you understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of this charge?
Yes, sir.
Then listen as the state steps up to the microphone and tells us what their evidence would be if this case went to trial.
Your Honor, on September 8th of 2024, Deputy Sutton responded to a call for help at the Twice Daily on Jackson Phelps Road. He ended up going to 1001 Carl Perry Road. He made contact with Alexandria Smith, who stated that she had been in an argument with Mr. Krantz over owing $800. And in her statement regarding the argument, she said that there had been a firearm that had been discharged into the air and that she was in fear and sitting on the ground crying as a result. They did have contact with Mr. Krantz, spoke to Mr. Krantz about the incident. He had a similar story, almost the same, but it was missing and did not have any mention of a firearm or discharging a firearm. Between the two stories, the state has come to this agreement that whatever did ensue, there was an argument in which Ms. Smith was placed in fear of imminent bodily injury. Therefore, we have brought it down to a simple assault.
All right. Mr. Krantz, I'm not asking that you agree with those facts.
I have a whole separate case.
All right. This is the theft.
Yes, sir.
All right.
we
So
do
what
that
are the
now?
facts in the theft case?
In docket 19713 on January 8th, 2025, officers went to where the defendant was living here in Cheatham County for a knock and talk about a drug transaction. Noticed a new BMW motorcycle, ran the VIN number. It came back stolen. There was a trailer as well on the property. It was stolen out of Nashville as well. Mr. Krantz admitted to being in possession of those items, but just stated that he was borrowing it, I think, to fix it up for a friend. And once that was done, he was going to take it back.
Again, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? And move that microphone back. There you go.
Yes, sir.
Do you still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Vaughn has done a good job of representing you confidently.
Yes, sir.
Mr. Vaughn, you know of any reason he should not enter this plea? Anything further from either one of the state representatives? Take it by your silence. The answer is no.
No, for both of us.
Then Jonathan Krantz, docket number 19710, upon your plea of no contest to simple assault, I find you guilty, sentence you to 11 months 29 days in the county jail that will be suspended to supervised probation with credit for time served and have no contact with the victim. Docket number 19713, upon your plea to the amended charge of theft, I find you guilty, sentence you to 11 months and 29 days in county jail. That will be suspended to supervised probation. That will also be served concurrently with the prior case. And your prior jail credits are all set forth by Mr. Vaughn on this document. So thank you. He needs to see probation. Who else we have?
Ready?
Page number 4, document 19849, Tracy Perry.
Judge, Mr. Perry is also mine. That'll be complete. Mr. Perry's got a multiple count indictment. Your Honor, he is going to be pleading no contest to count 1 and 2. Both are evading arrest. Count 1 is of the felony variety, and count 2 is of a misdemeanor variety. He will receive 4 years in TDOC suspended to state probation as to count 1, and 1129 suspended to state probation, which will run concurrent with count 1 on count 2. All other counts can be dismissed. This will be a range one. He's got jail credit for 12, 27, 25.
Perry, raise your right hand. Let's place you under oath.
Yes,
Thank you. State your full name for the record.
Trace C. Perry.
Mr. Perry, you're here today charged with 2 different counts, and you've heard your lawyer go over what the agreement is. But have you been shown a copy of the charges, talked them over with Mr. Vaughn, you and he discussed the range of punishment you're facing, as well as any possible defenses you might have to the state's evidence?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of nolo contendere. You may have just heard me explain. That means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial. And I'm going to use their evidence to find you guilty according to this agreement. Does that make sense?
Yes, Your Honor.
Do you understand, however, that you can plead not guilty and have a speedy and public trial by jury in this court?
Yes, Your Honor.
Do you understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you could not afford your own? Of course, we've done that with a public defender.
Yes, Your Honor.
You understand that trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you would, and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand that you would not have to testify or prove anything at your trial, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out with the state.
Yes, Your Honor.
And you understand that's going to result in you having 2 additional convictions, 1 felony, 1 misdemeanor, that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, Your Honor.
You understand everything I've explained to you.
Yes, Your
Do
Honor.
you want to plead no contest according to this agreement and waive your right to a trial and to an appeal?
Yes.
Is your decision to plead no contest today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
No.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, Your Honor.
And listen as the state tells me what their evidence would be if this case went to trial.
Yes, Your Honor, in docket 19849 on December 26, 2025. Initially, deputies were notified of a reckless driver entering Cheatham County, I believe from Dixon County. They picked up that pursuit, chased the defendant for a while, attempted to spike strip his vehicle. That was not successful. And they, because of the nature of the chase, chose to terminate the pursuit for safety concerns. At a later time, Ashland City on that same date picked up the pursuit. And again, the defendant was driving erratically all over the road, trying to evade police. He was eventually apprehended and identified by both agencies.
And again, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, Your
You
Honor.
still wish to plead no contest?
Yes.
Are you satisfied with your attorney's services?
Yes,
You feel like Mr. Bond has done a good job of representing you competently?
absolutely.
Mr. Bond, you know of any reason he should not enter this plea?
No, no, Judge.
Anything further from the state?
No, Your Honor.
Then is it Tracy Perry?
Trace.
Trace Perry. Upon your plea of no contest to count one, I find you guilty. Sentence you to 4 years, Tennessee Department of Corrections, suspended to state probation on time served. Count two, evading arrest, you're sentenced to 11 months, 29 days in the county jail. That will be suspended to state probation to be served concurrently with count one. You get pre-sentence jail credits from December the 27th, 2025 until today. Thank you. He
Thank
needs
you.
to see probation.
This hearing ends with a twist that few expected. Rather than deciding who owns the property or whether the adverse possession claim succeeds, the judge grants the request to step aside out of an abundance of caution. It's important to note that this is not a ruling in favor of either party. A judicial recusal simply means another judge will take over to ensure confidence in the fairness of the proceedings. The underlying dispute remains unresolved, and every claim, piece of evidence, and legal argument will eventually have to be presented before the newly assigned special judge. For now, both sides leave without the central question being answered. Who, if anyone, has the legal right to this property? Cases like this show how courtroom procedure can sometimes become just as significant as the facts themselves. If you found this courtroom showdown interesting, let us know in the comments whether you think the judge made the right decision to recuse himself. And if you enjoy detailed courtroom breakdowns like this one, don't forget to like this video, share it with others, and subscribe for more real courtroom cases and legal analysis every week.